Hello, and thank you so much for joining us. My name is Avery Coleman, investment analyst here at Cornerstone Advisors Asset Management, joined by Angela Oz, Director of Plan Giving. We're back to defang another intimidating topic today, as I'll be bombarding Angela with questions about registration and some of the legal requirements associated with the CGA pool. Hello, Angela.
Hi, Avery. How are you?
I'm pretty amazing. How are you doing?
Very good, thank you.
So I'm ready to learn a little bit about registering for CGAs and some state stuff.
All right, let's do it.
So what determines what state an organization has to register with in order to issue CGAs? Is it the location of the organization or the donor?
Sure. So before we get started here, let me just start with a blanket disclaimer here that we are not here to offer any type of tax or legal advice. Make sure that you're consulting your legal counsel and all of your advisors on anything related to registration, because it is always changing and it's very specific to your organization. But with that being said, registration really depends on where you're doing business. So what is doing business? Some organizations feel that doing business means that you're sending marketing materials. Maybe you're meeting with a donor. Maybe you're actually having them sign a gift annuity agreement. So with that, depending on where your donor lives, will determine if you need to register in a specific state.
So if your donor lives in New York, but your organization is in California or Nebraska, then you would need to register with New York to be able to have that person in your donor pool.
Exactly. If your donor resides in the state of New York is highly regulated and requires registration. You would therefore need to register in the state of New York, even though you're not located there.
And then how does the location of the organization come into play? Do you have to also register wherever you're located in addition to your donor, or is it one or the other?
Sure. So this is where it gets a little bit complicated. So there's another way of defining doing business. And with this definition, it would require a physical presence in that state, meaning that your organization is actually located there in a specific state, and therefore you run all of your business under that state regulation. This is definitely a less popular way of looking at it. Very few organizations actually follow this guideline because the states are not always in favor of it. But regardless of where your donor would live, you would only be registered in the state that you're actually located in.
So like if you were registered in Florida, but you had a donor in Nebraska, you would register only in Florida, and that's the less stringent. So, it doesn't necessarily go with the tip your lawyers, consult with all the people crowd, right?
Exactly, yeah. But again, this is up for legal interpretation. Definitely seek legal counsel on this topic because like I said, that second definition is much less popular as far as where to register.
Okay, and what happens when a donor living in a non-registration state sets up a CGA and then subsequently moves to a state where registration is required?
Sure, this happens all the time. I think the best way to understand this is with an example. So let's say you have a donor who is living in Pennsylvania. Pennsylvania does not require any type of registration. They set up a CGA. A couple of years later, they reach back out to you and they are interested in setting up another CGA, but now they have retired and they moved to Florida. Florida is a state that requires registration. So therefore, now that that individual lives in Florida, you would need to register with the state of Florida before issuing another CGA on them, even though you didn't have to register before that.
But the previous CGA will remain, no changes needed for that.
Exactly. That previous CGA has a registration state of Pennsylvania, but this new one would now have a registration state of Florida.
Okay. And do all states require an annual filing and registration, or just some, or how much is that?
Sure. So no, not all states require registration and filings and all of that. I like to look at it that there's 4 tiers of state guidance as far as CGAs and registrations are concerned. So starting at the most strict, we have states that their law requires a segregated reserve account for all charitable gift annuities, an annual report, detailed application, really the most strict type of state out there. There's 11 states that fall under that category. Then there's states that will allow for an exemption, but you do need to notify them that you are issuing charitable gift annuities in that state. And there's 14 states that fall into that category. Then there's states that don't require a notification and allow for an exemption. And a majority of the states fall into this category. There's 22 of those. And then lastly, with the least strict states out there, there's 4 states that actually, they don't even address gift annuities. So there's really no guidance on how to issue them, registration, or anything like that. But refer to the ACGA website. Guidance is constantly changing from the states. There's states that previously were very, very strict with their registration guidelines, and now maybe they're not. So just keep up to date with that. It's very important that you know which states require what in order to issue charitable gift annuities there.
And I assume like registration is required before you get the donor, or how's the timing work around that?
Yes. So in states that registration is required, a charity needs to either apply for and obtain a permit prior to issuing that first charitable gift annuity, or send a notification no later than at the same time that you're entering into that first gift annuity contract with the state. But again, check out the ACGA website. They will guide you on what to do for your specific situation.
Okay, thanks. You mentioned earlier that there are sometimes surplus reserve requirements, things like that. Can you talk a little bit about that and how it's calculated?
Sure. So let's start with the definition. The reserve is what the charity needs to finance any future gift annuity payment. It's really all the obligations rolled up and what do they have to pay. This amount does fluctuate, but it really depends on the size of the annuity payment, how old your annuitants are, mortality rates, and interest rates. And on top of that required reserve, some states also require an additional amount of protection within that segregated reserve fund. And this is called a surplus. So it's another percentage on top of what the state requires within that account in order to protect your annuitants and make sure that there's enough funds in that pool for them.
So not necessarily something that we could just like take our calculator out and do some addition and some subtraction. So it's actually something that needs to be referenced.
Yes, we use PG Calc's gift wrap software to do that calculation. You could do it by hand, but there's a lot that goes into it. So if you're ever in a situation that you need to know what state, what the requirement is for that specific state, just let us know and we can run that calculation for you.
And you mentioned a segregated reserve pool. What is that? What's that? How is that different?
Sure. So some states, there's actually 14 of them that actually require that all the donations from charitable gift annuities are in its own separate account. So this means that it cannot be commingled with any other type of donation. They need to be completely separated from each other. Some states even require that only donors in a specific state, that their CGA assets are in one specific segregated reserve fund and everybody else is in another one.
Okay, so like if I have a donor in California and I have a donor in Oregon, then the California donor might have to be their own pool, and then Oregon can be mixed with everybody else as long as their laws don't say they need a segregated reserve. Is that how that works?
That's correct. California is one of those states that always requires that their donors are in a separate account. All of those assets need to be managed in accordance with the guidelines from the state, which are very different than other states' requirements, which is why they need to be in their own individual segregated reserve fund.
And what happens if a organization, a CGA pool, is under the reserve requirement? Are there harsh penalties? Is it something that you can just kind of make up later on?
Yeah, so this does happen. Let's remember that these are investments. They will fluctuate. You will have situations where your donors outlive life expectancy and you're paying them more than what they put in and that we're returning in the market. So this does happen. It's very important that if you are in a state that has annual filings and reserve requirements, that you are monitoring it regularly, at least annually, so that you can be in compliance with the state. But definitely prior to when you're sending out any type of filing or completing any type of filing, make sure that you are within those reserve requirements. Otherwise, you could be out of compliance with the state and they will notify you that money does need to be deposited and you would have to pull that from some type of other operating fund or somewhere else within your charity in order to get that balance up to their required level.
And is it something you need to have at all times during the year be above that level, or is it like December 31st is when it has to happen? How soon do you have to take action if you notice that the pool is below reserve requirement?
Yeah, it's definitely most important that it's there before you submit that filing. So if you are filing based off of quarter or calendar year end, make sure that those assets are at the required level prior to 12/31. If you have a fiscal year end that you're filing from, make sure that before that fiscal year end period is over, that your assets are up to the required amount in order to be in compliance. I mean, assets are going to fluctuate. It could be the middle of the year and maybe the market has had a correction and has dropped significantly. Your reserve requirement might be below the amount, but you don't need to jump on it right away. Just keep an eye on it, see if you have to make any deposits later on in the year.
Okay. And is there anything else that we might have overlooked today, not brought up, that is important towards registration, any reserve requirements or anything that we've discussed today?
Yeah, I think one thing that we didn't touch on that I think is also very important to note is that registering to issue charitable gift annuities with donors is different than registering with the state as a nonprofit. Those are two totally separate things. You might be registered in all 50 states to solicit gifts as a nonprofit, but that does not mean that you are registered in all states to issue charitable gift annuities. So again, make sure that you're in communication with your legal counsel and all of those individuals at your organization that are involved with all of this to make sure that you're in compliance and you're understanding each state's requirements so that you are just following all the rules and in good standing with the states.
That makes a ton of sense. Tip your lawyers, everybody. Thanks a lot, Angela. I appreciate you stopping by and talking with us and educating us today about CGAs.
Thank you so much.